Be ready for the dictation. Start.
The appellant is in appeal aggrieved by the order of the High Court, claiming inadequacy of compensation granted to him in a motor accident case. The appellant was travelling in a bus of the respondent corporation and met with an accident on 19 February 2010 due to rash and negligent driving of the bus driver who hit a lorry from behind. As a consequence of the injuries suffered, the left leg of the appellant had to be amputated. The tribunal awarded a compensation of Rs 408,000. The High Court in appeal enhanced the same to Rs 510,000. The appeal preferred by the respondent corporation was dismissed. Shri Ashwin, learned counsel for the appellant, submitted that the compensation enhanced by the High Court is grossly inadequate considering the nature of injuries suffered. The appellant was a painter by vocation. He had a daily income of 300 rupees per cumulated at 9,000 rupees per month, supported by the evidence of his employer PW.2, which has been wrongly rejected. The permanent disability of the appellant, contrary to the evidence of PW.3, the treating doctor, has been wrongly fixed at 25% of the whole body without any reasoning to support the same in the nature of the injury, suffering, future medical treatment and loss of future income caused to the appellant. Shri S.N. Bhatt, learned counsel for the respondent, submitted that the High Court has reasonably enhanced the compensation and it calls for no interference. The appellant had failed to substantiate the claimed income with substantive evidence. The extent of disability suffered has been adequately assessed. The evidence of the employer and the treating doctor have all been considered adequately. We have considered the submissions on behalf of the parties. The appellant was initially taken to the government hospital on the date of the accident but was shifted to a private hospital on 25 February 2010 where he remained as an inpatient till 16 September 2010. There was no alternative to amputation and fixation of an artificial leg. The physical disability suffered by the appellant of the left lower limb was assessed at 75%, which was about 37.5% of the whole body. PW.3 further opined that the appellant had suffered shortening of the left lower limb by 3 centimeters. He could not stand independently or walk without aid of a walker or attendant. The appellant cannot sit cross-legged, squat or use an Indian toilet. He could not climb up and down a staircase. The appellant was incapable of any manual work including painting. The appellant, who was 45 years of age, considering average life expectancy of 65 years, would require at least 3 further replacements of the artificial limb in his lifetime, the cost of which was assessed at approximately between 75,000 rupees to Rs 150,000. The High Court enhanced the monthly income of the appellant to Rs 500. He has been awarded a sum of 1 lakh rupees per towards pain and suffering and 7,350 rupees per towards medical expenses along with 21,000 rupees per for attendant charges. The loss of earnings during the period of treatment has been enhanced by the High Court to Rs 66,000. Conveyance charges have been paid at Rs 10,000. We find no reason to interfere to the aforesaid extent. The physical disability of the appellant without any reasoning has been assessed at 25% of the whole body with which we are unable to conquer. The compensation granted towards loss of future earning on account of disability at 2,31,000 rupees per is considered grossly inadequate in the facts and circumstances of the case, as also the compensation of 50,000 rupees towards future medical expenses and only 25,000 rupees per towards loss of amenities. PW.3 had assessed the physical functional disability of the left leg of the appellant at 75% and total body disability at 37%. The High Court has considered it proper to assess the physical disability at 25% of the whole body only. There is no discussion for this reduction in percentage, much less any consideration of the nature of permanent functional disability suffered by the appellant. The extent of physical functional disability in the facts of the case has to be considered.